Good afternoon. Welcome, everyone. First of all, I would like to express my gratitude to Rui Cunha Foundation for the invitation, especially to Mr. Rui Cunha. This is a very nice venue that I have been able to use to discuss with the audience some of the subject that I liked a lot. And today is very special because since the last session, which was held last week, which was in Chinese, and during this session, the question Q&A part, I was asked a question, and that question made me think about one aspect which was very important that I overlooked throughout my research. And then after that day, there was another person who came to me and told me about a case dealt with in the court, and which is very similar to the one that I talked on that day. So the importance of having this venue to discuss this kind of subject matter, for me, especially in this case, is that I not only can share my views on the subject, also I can learn from you all. So do raise questions, do point out objections, and make observations. If this is the case, I'm really thankful for the input that you might provide. So having said that, I will start with my presentation. As you can see, the role of the court in arbitration is the topic of this presentation. So arbitration and court are closely connected, although they belong to the different type of dispute resolution mechanism. Basically, in a broad category, we have consensual means and third-party determination. I'm not going into the details because of I have more information to share today than last week, so I will be very brief in some of the aspects. So that's why I will ask if anyone is interested in having a deeper analysis of these slides. I can share the PPT with you. Just tell me in the end of the session. I will provide to you if it is your interest. So consensual means we have negotiation and mediation. So I'm not going to talk about the details, the difference between them. Just to mention these two, the most common new consensual means of dispute resolution mechanism. And the third-party determination, basically we have litigation and arbitration. Arbitration is perceived as an alternative dispute resolution mechanism in face of litigation, just like many others dispute resolution mechanism. But because of the topic, I will highlight the relation between arbitration and litigation. So for that purpose, I will first go through what I will do today in this presentation. The scope of this presentation is to tell you why there are court interventions and when do they occur and for what. Why do the court intervene in an ongoing or in an arbitration to start? And regarding this presentation, I have to rely on some legal framework. Basically, I will rely on, of course, Macau arbitration law is 19/2019. And apart from that, in the area of arbitration, recognition and enforcement of arbitration award, we have three pieces of legislation, namely New York Convention on Recognition and Enforcement of Arbitral Awards, I would call it New York Convention, as anybody else does. And then we have the arrangement concerning reciprocal recognition and enforcement of arbitral awards between the mainland China and the Macau SAR. And also the same type of agreement which was signed between Macau SAR and Hong Kong SAR. This is the basic legal framework in the area of recognition and enforcement of arbitral awards. And also, we have an arrangement signed between the mainland and Macau regarding interim measures which were asked by the parties, which are asked by the party for the court to provide. So this is also the legal framework on which I will do my presentation. So my aim today is to give a panoramic view of the court interventions. So I hope that in the end of this presentation, you would be able to know not only the type of interventions, when they can occur, and for what purpose they occur, and the rationale behind all these interventions. And in the end, I would like to emphasize the attitude of our legislator towards arbitration. And so another aim is to emphasize two very important institutions in arbitration. One of them is arbitration agreement. As all you may know, arbitration agreement is the foundation, is the bedrock of any arbitration. So it underpins the whole infrastructure of arbitration, from the arbitration proceedings and beyond, as I will talk about this. And another institution which is also very important is the competence principle. This is a principle, I would say, is a tool to ensure arbitration is a real alternative to litigation, without which litigants are always, sometimes, asked to go back to court against their will to submit their dispute to arbitration. So in a while, I am more or less in the final part of this presentation, I will focus on this principle to let you know what exactly it means and how we should deal with it in articulation with arbitration agreement. So before going to all these types of court interventions, I have a slide which outlines the characteristics of litigation and arbitration. Again, I'm not going through all the details, just to highlight the importance of a few areas. When we face litigation, which means judicial proceedings, we are facing a public justice system, whereas arbitration is a private means of dispute resolution. In a litigation, the entity which hold the powers to settle a dispute is a national court, whereas in arbitration is the tribunal, composed of one or more arbitrators. And in litigation, the national courts are the natural forum. So people don't need any agreement of the other party, of its opponents. They can go to court without any previous agreement. Whereas in arbitration, this is one of the aspects very important, is that parties have to agree in submitting their dispute to arbitration. So this is where the arbitration agreement has its importance. And another aspect is related to the fact that national courts are readily available, whereas arbitration, the tribunal has to be set up before the real proceeding really starts. So this is where the difficulty starts to arise. So why do people go to arbitration and forget litigation instead of going to a place where you have all the things prepared for you, don't have to worry too much about what comes next? Why do people go there to arbitrate, submit their dispute to arbitration? So basically, there are a few areas where arbitrations is better than litigation. The strength lies on the speed. Not usually the arbitration can provide to the litigants. One of the important aspects is the finality of the arbitral award. We'll come to that in a while when we talk about the court systems. And then the flexibility of arbitration. So parties can choose arbitrator, parties can choose the procedural rules to guide through the whole procedure, and parties can choose the applicable law. Whereas in the court system, you are not able to do that. The area that you might be able to do that in refers to the applicable law, but usually you do it in the beforehand while you draft the contract. The parties will agree the applicable law. But in arbitration, you can do it even during the procedure and ask the arbitrator to apply particular sets of law, even the so-called amiable compositeur. I'm not sure whether my pronunciation is good enough. And ex e quoque e bono. These two ideas is to let the arbitrator follow some principles which is beyond what is provided by hard law. And one aspect is which is arbitration is more opted is because of it being confidential. So this is a rule in arbitration. So our arbitration law provides that in principle, every information of the procedure is kept secret. So for parties who are not willing to share their dispute to other third parties, they usually prefer arbitration. So the dispute is kept out of the public domain. And despite of being a private means of dispute resolution, arbitration provides a very important tool to the litigants, which is the award is enforceable just like any judicial rulings. This is provided in our arbitration law expressly. So parties, even going to arbitration, going private, still the final award could be enforced just like any judicial ruling. That's why people go to arbitration instead of going to court to ask for the national court to intervene and settle their dispute. But of course, as anything, there are shortcomings which I would like to outline here, which make litigants obliged to go back to court. So there are two areas in which arbitration is not good enough in a sense. So because arbitration is a private means of dispute resolution, sometimes it doesn't have sufficient autonomy because it lacks the means to ensure this autonomy. I'm talking about for the initiation of the arbitral procedure, if one of the party is not cooperative, does not want to cooperate in appointing the arbitrators or the arbitrator, then the party needs the help of the court. This is where the court pops in and help the parties to overcome this difficulty. And for the smooth running of the procedure, the court has also a role to play. For instance, the arbitration proceeding, the tribunal needs some help from a third party if this third party is not willing to help, then the court will intervene to help the parties, and also to enforce the decisions made by the tribunal, either decisions, final decisions in the awards, or interim decisions like asking the party to provide something, ordering the party to provide something, and the party refuses to cooperate. Then probably the court can be asked to intervene and help the tribunal to get the information which is needed. And another area that the court has to intervene is related to the legality of the procedure. Being a private mechanism of dispute resolution, it requires the agreement of the party to use this means, as I have just referred in a while. So for the agreement to be enforceable, it needs to be fulfill a set of requirements. So if it is not the case, then the court can intervene to supervise. So this is where the state supervision pops in, and which is carried out by the courts. And also to safeguard the legitimacy of the mechanism. Where being private, the states needs to intervene to check the validity of the arbitration agreement, just like I said, and the legality of the procedure in order to uphold the arbitration award, the final award. Otherwise, it would refuse enforcing or recognizing the award. So this is why people, even choosing arbitration as the means to resolve their dispute, they sometimes need the court to intervene either for assistance or for supervision. So after that, I can sum up that the reason why the court intervened is because arbitration does not have the coercion power to enforce its decision. That's why they require the court to give assistance. And then regard to the legality is where the arbitration is subject to the court supervision. And as to when the court intervenes, it could be before the arbitral proceedings, during it, or after the proceedings. So basically, before is when the parties need the court to help them to appoint an arbitrator or arbitrators, or during the proceedings when they need the court to intervene to grant an interim measure, for instance. And after the proceedings is when the party have the award, but when the losing party is not willing to comply with the order handed down by the tribunal. This is where, after the proceedings, the court can intervene. So in terms of the purpose of the intervention, we can have the assistance part, which is related to the arbitrators, interim measures, evidence, provisional measures, and awards. And to the supervision part, we have the arbitration and awards. So this is the 7 areas that the court can intervene to either to provide assistance or supervise the arbitration. So I will go through all this, although in a very brief way, because I want to leave some room for the final part, which I find it very interesting, and I want to share my views with you. Okay, so having said that, I would like to emphasize one thing which is very important, which is laid out in the Macau arbitration law, which is the guiding principle of this kind of intervention, which is minimum intervention. So the court is only allowed to intervene when it is specified in the arbitration law. So when you cannot find a way for the court to intervene in this law, the court is not entitled to intervene. Okay, so all this intervention is provided for in the Macau arbitration law, as I will show you from now on. So I'll start with the assistance part. The first one is related to the arbitrator. So it can be related to the appointment of arbitrator, removal of the arbitrator, or termination of an appointment made previously. So in regard to the appointment, we can be dealing with an appointment of a sole arbitrator or the presiding arbitrator or replacement arbitrator or additional arbitrator. As you may know, sole arbitrator is the only one arbitrator that which will compose the tribunal. Presiding arbitrator is the one that presides the whole proceedings with 2 or 4 or 6 arbitrators by his side or her side. So the court also can intervene in this area to appoint the presiding arbitrator. Replacement arbitrators occur when the parties, when an arbitrator for whatever reason is left the proceedings. So there's a need to replace that arbitrator who has left. Then the court might have to intervene to appoint a replacement arbitrator. Additional arbitrator refers to the case when the parties have decided on an even number of arbitrators, 2, 4, 6. So when it comes to the decision, in principle, majority wins, the opinion holds. But sometimes, if it is even, we can come to a situation where one holds an opinion, another holds another one. So in this case, there might be a necessity to appoint another arbitrator to break the impasse. Okay, so this is where the additional arbitrator pops in. And there is another arbitrator provided in our arbitration law, which is an emergency arbitrator. This is an arbitrator who specifically is appointed to deal with provisional measures, which are measures granted by the tribunal, but before the tribunal is set up. So imagine a situation where the party, one of the party needs to ask for freezing up some assets. So before the tribunal is set up, there's no arbitrator. So the party might need an emergency arbitrator to do this work. So this is the role of an emergency arbitrator. So now, regarding our appointment, the Macau arbitration law does not provide for the appointment by the court of the emergency arbitrator. My question is whether the court can be asked to do this appointment. This is a question that I have. I tend to say yes because I'm very pro arbitration. So I tend to say yes, but of course I accept different views, and I don't have a very clear position on that. I tend to say yes, but observations and questions are welcome in this regard. So about where and how this, I'm not going into the details because you can see from the arbitration law and the relevance provisions are here outlined. And for the removal, also because the arbitrator is perceived as not impartial, not independent, or doesn't have the skill that the parties has expressly said that they wanted that the arbitration has. In this case, the arbitrator can be removed. For this purpose, the court can also intervene. The circumstances the court can intervene is provided in Article 29. Again, I'm not going into the details. You can check, and from the slide I have outlined. And for the termination of appointment, when does an appointment can be terminated is when the arbitrator is not able to fulfill his or her duties. For instance, the arbitrator has fallen ill for a long period of time. The parties cannot wait. So in this occasion, there might be a need to terminate the appointment previously made. Or the arbitrator, for some reason, does not fulfill. For instance, the arbitrator has so many arbitrations ongoing, he or she is not able to answer the calls made by the parties. In this scenario, probably the parties might think about terminating the appointment. So again, when the party have problem in doing so, the court might be asked to intervene. And regarding the procedure, our law is very pro-arbitration, as I will show for throughout my presentation. So one of the aspects is most of the intervention that the court is required to do. The arbitration law provides that the procedure follows an expedited proceedings, which means that it is, how do you say it? It keep going on during the judicial holidays, and it takes precedence before other works that the court might have. So this is one area that I applaud the arbitration law, which give an emphasis on the need that the party have to make the procedure more speedy. And another area that the court might intervene is related to interim measures, is where the measures are granted by the court and not by the tribunal. So the arbitration law also provides for this possibility. So about the types, I'm not going to mention in detail because it's provided in our Civil Procedure Code, and it can be granted before the tribunal is set up or during the arbitral proceedings. And one important aspect is that the arbitration law states that this help can be provided both for arbitration in Macau or outside Macau, which is not the case under the previous arbitration law. So under the previous arbitration law, the relevant rule is not so expressly, clear as the new arbitration law. When the previous arbitration law is in force, the court of second instance had a chance to decide a case where one of the party came to Macau, where the arbitration is, if I'm not wrong, is agreed to be held in Hong Kong. So one of the parties came to Macau and asked Macau to intervene to grant an interim measure. In this case, the court rejected jurisdiction, saying that this was not stipulated in the arbitration law. Now, with the new arbitration law, this is no longer the case. So whatever kind of arbitration, local or foreign, the parties can come to Macau and request the Macau courts to intervene and grant an interim measure. So again, here also the procedure follows an expedited proceedings. So this is another aspect that I would want to highlight, the pro-arbitration stance of our legislator. So just now I was talking about interim measures in general. So wherever the arbitration is held, parties can come to Macau and ask for these interim measures under Article 15. And so I should have put the article is Article 15 of the arbitration law. But we have a piece of legislation which deals with a situation where the arbitration is held on the mainland, or the arbitration even is held in Macau, but the parties want to ask for an interim measure on the mainland. Because we can rely on this piece of legislation that I mentioned just at the beginning of this presentation, which is the arrangement concerning mutual assistance on interim measures in arbitration between the mainland, China, and Macau SAR. So if it is the case where a arbitration ongoing in Macau, then the parties can go to China and ask the Chinese court to grant an interim measure under this arrangement and not under their domestic law. And the opposite is the same. So when a Chinese arbitration, the parties of it want to have an interim measure granted in Macau, they can rely their request on this arrangement. And in this regard, I would just mention one thing, that for this arrangement requires that if the arbitration is in Macau, I mean the seat of the arbitration is in Macau, this arrangement requires that the arbitration is an institutional arbitration, opposite to ad hoc arbitration. So if the parties is having an ad hoc arbitration, they cannot rely on this piece of legislation and go to China and ask for an interim measure. So this is very important. So the scope of this arrangement is rather limited, because we are here in Macau is allowed to have institutional arbitration and ad hoc arbitration. But when it comes to interim measures to be requested in China, on the mainland, then an ad hoc arbitration cannot rely on this arrangement. So another area that I would like to focus is the assistance that courts can provide, courts in Macau can provide, is on the area of evidence. So the parties can request the tribunal to help them to gather evidence on a specific aspect of the proceedings. So this is very simple, straightforward. I'm not going into the details, just to again highlight the procedure. Again, is according to the arbitration law, it has to be held in expedited proceedings. So this is the fourth area in which a court in Macau can be helpful. Is for the grant related to provisional measures. So provisional measures, as opposite to interim measures, they are granted by the tribunal. So instead of being the court, the entity to grant, is the tribunal that grant these kind of measures. So it's called provisional measures under our arbitration law. They can be urgent or non-urgent. If it's not urgent, then you can wait until the tribunal is set up, and then you ask the tribunal to appreciate the request and grant the provisional measures. But sometimes the parties cannot wait. Then they have to request the emergency arbitrator. Just I mentioned a while ago about this new figure, which is something new in the arbitration law, to grant these measures. So once granted, again, the parties can have a problem of enforcing it, because, as I said, the tribunal does not have the coercion power as the courts. So they might need the intervention of courts to help them enforce these kind of measures. Before I go into this, I would like to highlight one important thing. Is that while the interim measures follow our civil procedure code, so the types of interim measures are laid out in the civil procedure code. Here in the provisional measures are those listed in the arbitration law. One of the interesting thing is that regarding the preserving evidence, which is according to our civil procedure law, is not an interim measure. It's not the scope of interim measure, but the legislator of the arbitration law put it in this area where of the provisional measures, party can ask the tribunal to grant a measure in order to preserve certain type of evidence relevant to the resolution of the dispute. This is one thing that I would like to highlight here. And so after granting it, it comes to the problem of enforcing it. So here is where the court pops in. So again, for this kind of assistance, our law allowed arbitration, allowed this help both for arbitration here in Macau and arbitration outside Macau. But of course, in this scenario, the order granted by the tribunal has to be recognized before enforcement. So that's why there is an entity with the power to recognize, which is the Court of Second Instance, and an entity to enforce it, which is the Court of First Instance. Again, the law requires that this kind of proceedings to be held in an expedited proceedings. The last area where the court provides assistance is related to the final award handed down by the tribunal. So in this area, I have separated two scenarios. One scenario is those where the award itself is not enforceable in Macau per se. Why? It's because the seat is located outside Macau. The party who is willing to have it enforced in Macau has to go through a procedure which is called recognition of the award, which is provided in the arbitration law and also in the our civil procedure code from 1199 onwards. So before I go into the details of this procedure, I would like to highlight this. In this area of recognition of arbitral awards made outside Macau, we have to distinguish four scenarios. First, which is defined, this scenario has to do with the seat of the arbitration. If the seat is on the mainland, then it's one regime. If the seat is in Hong Kong, then it's another regime. And if the seat is in a contracting state of the New York Convention, then it's another regime. And all others, the fallback regime is provided for all other types of arbitration not held in these three areas. So about these four types of regime, I will come to it in a short while. For now, I would like to highlight this important thing. According to the arbitration law, it should follow the expedited proceedings, which I would argue that supersede Article 10 of the two arrangements, the arrangement between Macau and Hong Kong and the mainland and Macau, whose Article 10 provides that the request should be dealt with as fast as possible. Why do I say that? Because following an expedited proceedings, the procedure has to be faster paced than the request should be dealt with as fast as possible. The court is not entitled to say, I am very busy to deal with an important case, so that's why I don't have time for now. I'll find time later on. It cannot do that. It has to be dealt with as in 5 days or 10 days and during the judicial holidays. So this is a very important tool to allow the arbitration to be appealing to the litigants. This is another important aspect that I would like to highlight. So because it's more favorable to arbitration, I would argue that repeal this provision in the arrangements. And regarding the grounds of refusal, and another important aspect that I would like to highlight is, according to all these 4 regimes, the recognition is only denied when the grounds of refusal are found, which is something very different with the Civil Procedure Code, which states that recognition is only granted if requirements are met. As you can easily see the difference. To have the recognition granted, according to the Civil Procedure Code, the interesting party has to present the case, argue that the requirements to be recognized are met because of this, of that, of that. This is on the burden of proof of the requesting party. Whereas the new rule is the requesting party, in principle, just furnish the necessary documents, and in principle, the recognition would be granted. Who has the burden to avoid the award to be recognized is the requested party. It has to provide proof and demonstrate to the court that the case has some problem that forbids the court to recognize it. So you can see the difference. It makes a big difference. So I would argue again that the arbitration law and all these 3 regimes supersede what is provided in the CPC. Again, but I would alert to this fact. This Article 1200 in the CPC does not deal only with recognition of arbitral award. It also deals with recognition of foreign judgments, judgments granted outside Macau. So when I say it's superseded, doesn't mean that whole provision does not hold regarding judicial rulings. Okay, this is one disclaimer that I want to make to avoid any misunderstanding. So now I'll go through every one of these 4 regimes. So depending on the seat, we have mainland China, Hong Kong, New York Convention states, and other jurisdictions. In regard to this, here in Macau, only the contracting states of New York Convention can rely on the New York Convention. Why? Because China has the People's Republic of China, when it acceded the New York Convention, has made a reservation, which is called reciprocal, if I'm not wrong, someone can correct me, reciprocity reservation, which says, I will apply the New York Convention only to the awards made in a contracting states. So all other kind of awards follows by domestic law. Okay, so imagine that, for instance, a country A, which is not a contracting state, because of this reservation, will follow in this 4th category. So we will apply the regime accordingly. This is because of the reservation. I was saying that there are different regimes because mainland China awards, we will use the mainland Macau-SAR arbitration awards arrangement, and to Hong Kong awards, we will use the Hong Kong-Macau arbitral awards arrangement, and to contracting New York Convention contracting state, we will use the New York Convention. Of course, in this three scenario, we will also combine the regime with the Macau arbitration law when there's no, on the case of missing situation where the arrangement or the New York Convention does not provide any solution. So all other types of awards, we would apply the arbitration law, and again, the CPC Article 1199 21205 in principle. Why? I will talk about this in a while. So these four types of situation also has effect on the types of award which are recognizable. Is that correct? Can be recognized. So regarding mainland China award, we only deal with, when it comes to Macau, to our recognition, according to the arrangement, we will only deal with civil and commercial award. And very important, we only deal with mainland institutional award. And then in the case of Hong Kong award, we can deal with any types of award, and both international, institutional, and ad hoc. In the case of a New York Contracting States award, we can only deal with commercial award. This is because the second reservation that the People's Republic of China has made when it acceded to the convention, which is the commercial reservation, which about the definition of commercial, I would argue, although the arbitration law does not define what is commercial arbitration, I would argue that it's applicable the Article 1, Note 2 of the ancestral model law, which is the base of our arbitration law, which is stated that the definition of commercial should be given a wide interpretation as to cover, namely, so on. So this is the definition that I would argue that what defines our commercial arbitration. And for other jurisdiction, I tend to say that it's related to any type of arbitration, commercial or civil. And also here in these three areas, either institutional or ad hoc arbitration is covered, so we can ask for the recognition of both this kind of arbitration awards. And I have outlined some special features of these four regimes, but because of the constraint of time, I will only outline two aspects. One related to the mainland China arrangement, or the mainland award, regarding the mainland awards. So in this arrangement, it's stated that the winning party can initiate enforcement procedure concurrently, which means it can ask the Macau court to enforce the award, and at the same time ask the mainland courts to enforce the very same award, which is very helpful for the parties. They won't lose time. Imagine I have an award that grants me $1 million or patakas or yuans. Then I can hold this piece of award and come to Macau and ask the Macau court to enforce the award and have this recognized and enforced it, while I'm also ask the mainland court to do the very same thing. So I don't lose time, because time is money. If I allow the party to stay still in Macau, probably the party will try to hide its assets, and when the time comes, I will not be able to have anything to ensure that the award can be enforced. So this is a very important tool that I applaud for the legislator in this arrangement to have agree on this important tool. And another special feature relates to the New York Convention. Its Article 3 provides that equal treatment, so which states this way: there shall be no imposed substantially more onerous conditions or high fees for or charges on the recognition or enforcement of arbitral awards to which this convention applies than are imposed on the recognition or enforcement of domestic arbitral awards. So the convention has the cautious in providing a very important way to ensure that the parties of foreign awards can have the same treatment and not discriminated during the process of recognition and enforcement. So finally, in this regard, I'll come to the grounds of refusal of recognition. As I have said just now, the refusal is only happens when the grounds for refusals are met and proven by the requested party, which is very important. So for this reason, I would argue that the Article 71 of the arbitration law superseded Article 1200, as I said before, and also Article 1202, which states the following, which is very important, which says, where the losing party is a resident in Macau and has the mechanism law applicable according to mechanism conflict of law rules being applied, the decision would have been more favorable to the respondent, then the respondent is entitled to request the court to deny recognition. So this is something that I don't agree with. It's kind of protecting our own residents despite of having an award that have gone through all the problems raised by the party during the proceedings, but just because it's against a resident of Macau, and just because in the eventuality of applying mechanism law according to our rules of law provision, conflicts of law provision, then the outcome would be more favorable to the respondent, then we will reject recognition, which is something that I don't agree with. So I would argue that the arbitration law repeals this part, but it's debatable, and welcome any suggestion in this regard. So this is the part regarding recognition. I lost one slide. Yes, next. So after recognition, in case of a award made outside Macau, the next step is the enforcement of the arbitral award. In this aspect, the intervention of the court is to enforce it, because the tribunal does not have the power to ensure that the non-compliant party to comply with the determination of the tribunal. So here, again, we can talk about arbitration held in Macau and arbitration located outside Macau. So for this kind of award, as I have said just now, we have the parties need to go through a procedure which is for the recognition of the award. After that, the party can ensue the enforcement phase. Whereas when the award is granted in Macau, the party are required to ensure that the award has become binding and final. So become re judicata. So no more argument about the ruling or the determination by the tribunal. Whereas in the case of foreign or awards made outside, there's no such requirement. I will come to that in a while. I can come to this immediately because according to arbitration law and according to the arrangement, the two arrangements regarding arbitration awards and the New York Convention, so the four pieces of legislation related to the enforcement of arbitral awards, recognition and enforcement is not necessarily denied if a proceeding in the seat of the arbitration in order to set it aside is ongoing. Imagine the parties have an award granted outside Macau, and the losing party asks for the court in this jurisdiction to set aside the award. Even because of that, the winning party can come to Macau to ask the Macauese court to enforce it. So these four pieces of legislation, all of them says that there is the possibility of suspending the recognition and enforcement procedure and ask the losing party to provide security for that purpose. So which means that even the award made outside Macau has not become binding and final like the local awards. They can ask Macau to recognize and enforce it, which is something very, very important to know. And other aspects I'm not going to go through. Final note that I want to mention is just like the interim measures arrangement, when it comes to Macau awards, we have also this facility of having the award recognized and enforced on the mainland and in Hong Kong under the same arrangement. So again, for the Macau awards, the Macau awards has to deal with civil and commercial matters, and here we have the luck of allowing our institutional arbitration and ad hoc arbitration. So even the arbitration was ad hoc, the award can be recognized and enforced in on mainland China, where up to a certain point, I'm not sure whether now is the case or not, up to a certain point at least, does not accept ad hoc arbitration on the mainland China. Maybe someone can help me whether nowadays is possible to have ad hoc arbitration on the mainland.
Especially in the new Chinese arbitration law, in special economic zones, it is possible to do ad hoc arbitration for disputes that relate to economic activity within the special economic zones.
Okay, so I have an idea that the new arbitration law in China has provided something on this, but exactly what I didn't have time to research, so I was not sure whether this was the case. So thank you for the help, which is again This is what I mentioned at the beginning. So it's very helpful because I become richer after this kind of presentation. So, but going back to this situation where the institutional arbitration or ad hoc arbitration, all of both are possible. The awards granted in these two types of arbitration can be enforced and recognized on the mainland. And in Hong Kong, there's no limitation on the types of awards, both in any matter and on institutional or ad hoc can be enforced and recognized in Hong Kong if they are made in Macau. So similar rules are applied, provided in the arrangements. One interesting aspect that I didn't mention just now because of this, Article 6 of both arrangements provided that the request has to be filed within the time limit provided in the relevant law. Macau doesn't have any rule that obliges the party to go to ask for enforcement of the award. So recognition and enforcement. So party can wait for a few years or 10 years or whatever, as long as the right doesn't expire. Prescribe, I don't know how it's called in Portuguese. So we have a duration in which a certain right is valid. Afterwards, it kind of expired. So, but in Macau, we don't have the time limit for the winning party to file a recognition and enforcement request. Whereas in China and in Hong Kong, there are this time limit. On the mainland, it is 2 years, provided in Article 250 of the Chinese Civil Procedure Law. And in Hong Kong, is a time limit of 6 years, provided by the Limitation Ordinance, referred to by the Hong Kong Arbitration Ordinance. So one should be aware of this kind of limitation. If you have an award handed down, you better go fast to avoid the expiry of the chance of asking mainland courts or Hong Kong courts to recognize and enforce it. So this is the area where our courts provide assistance. Now, we came into the part where the court exercise a supervisional role to ensure that the legality of the arbitration. So there are two areas that the court can intervene. One is related to the arbitration agreement. Arbitration agreement, the notion of it is provided in the arbitration law. I'm not going to read it. I don't need to read it. You can go and check and have the slides to analyze. The grounds for invalidating an arbitration agreement can be found in the arbitration law. I'm not going to go into this detail. What I want to emphasize here is arbitration agreement in itself is a contract between two parties or more. So they enter into an agreement to making a pledge to go to arbitration whenever a dispute covered by this agreement arises. So it's a pledge that they made to each other to go to arbitration instead of going to national courts. So in nature, this is a contractual nature of the arbitration agreement. But arbitration agreement has something very peculiar because it has the jurisdictional or judicial nature, because by agreeing to arbitrate, it has two immediate effects. One, I would call it negative, and one positive. What effects are these? The negative one It's on the court and the relevant judicial proceedings. It sees the jurisdiction that the court as the natural forum inherently has. So with the arbitration agreement, the court loses its jurisdiction over a certain case. And the court, because of that, has to dismiss the case. It has to refrain from going into the merits of the case. And according to New York Convention, Article 2.3, the court has to refer the party to arbitration. This is a negative part on the court and on the proceedings in the court. The positive part of the arbitration agreement is on the tribunal. It confers the jurisdiction which belonged to the court to the tribunal. There is a transfer of jurisdiction from the court to the tribunal. And this is the positive effect. And our legislature, to uphold this agreement, to make sure that the desire of the party to go arbitrate instead of going litigate, the legislator provided several tools to ensure that this desire is upheld. One of these is provided in Article 14.2 and 46.10, which states that if the disagreement on the arbitration agreement stands, which is one party argues that they agree to go to arbitrate, and another party rejects this assertion, denies that there is an arbitration agreement, then there's a dispute regarding the arbitration agreement. The legislator do this setup. The party still, although there's a conflict regarding the existence and validity of the arbitration agreement is still pending, they can initiate and continue the initiated arbitration proceedings without any problem. So this is very important, because if the party don't know exactly whether they should go to arbitrate or whether they should go to national court, then they should wait for the outcome of the conflict regarding the arbitration agreement. Then they, according to the outcome, go to court or go to arbitration. This is the logic sequence of things. But our legislator does not follow this path. It says you can initiate arbitration even though it is not clear at this point in time whether the parties should go to arbitration or should go to litigation. So you can initiate. If you have initiated, then you can continue while this problem is being solved. Okay, I'm sure that you understand the importance of this tool provided in our arbitration law. Another important tool in this arbitration law is the competence principle enshrined in Article 46.1, which allows the tribunal to rule on its own jurisdiction over the dispute. So in principle, my jurisdiction is being questioned. Imagine that I'm the arbitrator. My jurisdiction is being questioned because one of the parties says there is no arbitration agreement. In principle, I should not be the entity to say whether I have jurisdiction, right? The logic tells me that the parties should go to the court and ask the court whether there is an arbitration agreement. Then the party goes back to arbitration if the court says so, right? But our legislator, no. I'm not going to allow this because this will jeopardize the desire of the parties to go to arbitration. revealed in the arbitration agreement. If prima facie there is an arbitration agreement, then the party should go to arbitration and ask the arbitrator whether there is an arbitration agreement. Because you don't lose time going back to court and then wait the court to decide and then go back to arbitration. So time is money, as I said. So the arbitrator make this setup. You let the arbitration decide whether it has jurisdiction or not. Okay, this is the thing related to the positive side effect of an arbitration agreement. So to sum up this setting, I have made this sequence. So whenever a case is brought before a national court whose subject matter is covered by an arbitration agreement, what the court needs to do is provided in Article 14.1. This is the first step. The court should, hands off, refrain from entering into the merits, dismiss the case, and according to the New York Convention, refer them to arbitration. And more importantly, even this issue is pending. Imagine one of the party that does not agree with the court decision to dismiss this case, still argue and file an appeal to the court of second instance. When this is the case, Article 14.2 says you can initiate arbitration, or the arbitration initiated can continue. How come this happens that the party can, the party that is not willing to go to arbitrate can disagree with the court decision of dismissing the case and file an appeal? It's because the Article 14 states that the courts should stay off, the hands off, unless it finds the arbitration agreement null, clearly, very important, null, inoperable, or incapable of being performed. So when the court see the arbitration agreement and find this clearly, in Portuguese, manifestamente, clearly not valid, then, or cannot be performed, then the court can enter into the merits. If it is not the case, then the court should refrain from going any further and ask the party, please go to arbitration. I'm not the entity at this moment in time to deal with your dispute. So in this scenario, the losing party can argue, no, this is very clear that it is null. Why the court can ask us to go to arbitration? I'll file an appeal. So while this is pending, Article 14.2 says, party can initiate arbitration. If the arbitration has been initiated, that the arbitration can go on. So this is the first step. And the second step is provided in Article 46.1. It's the competence principle, which states that the tribunal may rule on this jurisdiction. So here is the principle, very important, as I just highlighted. So the tribunal can do its work by first ruling on its own jurisdiction. If it finds that it has jurisdiction, then go to the merits of the case. And third step is the sequence in which this problem of whether an arbitration agreement exists is the provided in Article 46.9, which is the rule that I put it this way: tribunal first and the court afterwards. What does it mean? That means that if the tribunal rules on its jurisdiction under Article 46.1, for instance, states that I have there is an arbitration agreement, that's why I am the competent entity to rule on the merits of this dispute, but the losing party does not agree, then he can or she can go to the court to ask the court to intervene according to Article 46(9). So this is a rule that I state as the tribunal first and the court afterwards. Okay, so you can see here there are courts and arbitration both have jurisdiction over the problem of arbitration agreement, but the law put a hierarchy on this power. First, the tribunal decides, and then the court decides on the very same question. And the fourth step is Article 46(9) also, which states that the party who does not agree with the decision of the tribunal can ask the court to intervene, but under the time limit of 30 days. And the decision provided by the court is not subject to appeal. So here I would argue that the court intervention is under timely limitation. It's timely limited. So you have to do it in 30 days, and you cannot appeal even though you don't agree with the court decision. So these two tools, tribunal first and the court afterwards, and this limitation, I would argue, is something very important to make sure that the tribunal can run the procedure, arbitral proceedings smoothly without interruption. So these are tools to avoid disruption on arbitration. Now, after that, all this is very interesting, and by chance, a few months ago, I came across a court decision handed down by the Court of Second Instance. It made me so puzzled for a few days. I couldn't understand the logic. And for me, that case is clearly an attempt to bypass the competence principle and to put obstruction on arbitration. And this is what we call the delaying tactics of the foreseeable losing party. This case is about proceedings or lawsuit initiated by the claimant, whereby he asked the court to make an appraisal or assessment. What kind of assessment or appraisal? By the way, it's provided, it's allowed under our Civil Procedure Code. You can ask the court to state something that there is a situation or there's a right on my part. This is possible. What kind of appraisal or assessment the claimant asked the court to provide is a declaration that stated there was no arbitration agreement. And the background of this is that the arbitral proceedings in Hong Kong over the substantive claims, substantive claims were underway. So in Hong Kong, someone filed a case before the tribunal, and the tribunal is dealing with this case. And in this case, the arbitrator had found already that there is a valid arbitration agreement and had asserted jurisdiction over the case. So you can see two parallel proceedings. One in Hong Kong, ongoing. The arbitration has entered into the merits phase because he has asserted his or her jurisdiction, whereas another case, court case, is filed by the claimant to deal with the very same issue, right? To whether there's an arbitration agreement which the arbitrator has already ruled. So when I read this, I said, something wrong. Something's wrong. It's something that the claimant wants to bypass the principle of competence. It cannot be that way. There must be some way to avoid this kind of delaying tactics. For a few days, I couldn't find out the solution. After a lot of thinking, I come up to an idea that I will share with you. But for now, I would like to share this ruling handed down by the CSI after the CFI, so the Court of First Instance and the Court of Second Instance. Both of them agree the objections raised by the respondent that there is the arbitration agreement amounted to a procedural obstacle for the judicial proceedings. We call it in Portuguese excepção dilatória, as provided for in Article 14.1. So which means that whenever there's a procedural obstacle, the court cannot enter into the merits. The court needs to dismiss the case because I'm not allowed to enter into the case. For instance, a very simple situation where the court does not have jurisdiction. For instance, an administrative case conflict cannot be submitted in the civil court. So when a civil court comes to come across an administrative dispute, the civil court has to reject the case, saying that I'm not able to enter into the merits because there is a procedural obstacle. This is the situation where the Court of First Instance and the Court of Second Instance find out in this case. They come to this conclusion that there is this procedural obstacle. So the CFI rejected the claims instead of dismiss the case, and the CSI dismissed the case and says that the tribunal had the authority to rule on the validity of the arbitration agreement and assert jurisdiction. This is exactly what Article 14.1 of the arbitration law states. Okay. After a lot of thinking, very hard, and
the claimant is the respondent in the arbitration proceedings, right?
I am not sure because the case. So the question is whether the claimant in the Macau lawsuit is the respondent in the arbitration proceedings. I have no information for that, but I assume yes, because if he is the claimant in the arbitration proceedings, that the first thing that he would have to say is that I have signed and agree to go to arbitration and sign an agreement with the respondent. That's why I'm seeking a tribunal to solve my case. So my guess is that the claimant here in Macau is the respondent there. But the claimant can be someone that say something yesterday and say another thing today. Maybe he asked the tribunal to intervene, but today, when he sees that the case is not going well with him, probably the award will be against him. Probably he will say something else different in Macau. But I'm not sure. I don't have any information to provide. But anyway, because of this case, I thought really hard, and finally, I came to this idea. I hope that you might help me to digest it, but this is my perception of the situation. We have to see that there are two tiers of contentions here. One is on the level of the substantive claims, where the party dispute whether the claimant is entitled to a certain compensation, to a certain right, to a certain action that the defendant should, respondent should take, or defendant should take, or the defendant has breached the contract. This is the substantive claims level. So on this level, what the party or what the parties in an arbitration agreement do is to say, regarding this dispute, we are going to arbitrate, and they sign an agreement before or when the dispute arises, right? So these substantive claims is covered by an arbitration agreement. And we have another level, which is the level of the arbitration agreement, in where the dispute relates to the existence of the arbitration agreement. If the parties the conflict is related solely with the existence or validity of the arbitration agreement, which is the scenario brought by this lawsuit, the mere appraisal assessment, where the claimant only asks the court to intervene to say whether there's an arbitration agreement. That's all. That's all he asked for. He did not ask the court to say, what is my right? What has the respondent done wrongly? He did not ask that. If you can still remember. So he asked only this, to a declaration that stated there was an arbitration agreement. Nothing more than that. So if it is this case, the scenario is totally different because of the following. On the level of the substantive claims, the arbitration agreement is instrumental. Why? The arbitration agreement only help to decide which entity has jurisdiction to oversee the substantive claims. If there is an arbitration agreement, the substantive claims are under the tribunal's jurisdiction. If there's none, then the substantive claims are under the court jurisdiction. So that's why I would argue that the dispute regarding the existence and validity of the arbitration agreement is instrumental. Instrumental to what? To the substantive claims. So because of that, the need to find out whether there is an arbitration agreement here because of the substantive claims has only one purpose, is to see who has jurisdiction. All right? So now we come to a situation where now who is going to tell whether the arbitration agreement is valid or not? The first instinct would be the court, because the court is the natural forum. The tribunal has not been asked to deal with the arbitration agreement. The tribunal is asked to deal with the conflict related to the substantive claims. The party say that we are going to arbitrate this conflict related to the breach of contract, related to the right that I say that I am entitled to, but you deny. It's the substantive claims that the parties submit to the tribunal, right? So the tribunal does not have jurisdiction over the previous question, which is whether the arbitration agreement exists. So therefore, there's a question. Who decides? I would say without provision in the law, I would say that it's the court. Are we on the same, are we tuning? Or are we tuned? So, but
if there was no law, so if there was not arbitration law, jurisdiction would be seized by the first forum, which will be accessed. So if you would, if the parties had started it, the disputes within an arbitration tribunal, the first decision would be made by an arbitration tribunal, and then there will be a question of whether that decision, and if the proceedings are started within a court, then it will be upon the court to decide. So I don't think there would be a or, as in court or the arbitral tribunal, rather it will be dependent on which forum was first tasked to take this decision, because arbitral tribunal in those circumstances, even if there was no arbitration law, would not claim to not have jurisdiction.
I'm sorry to tell you that I don't agree with you, because this is very simple. As I said, maybe I didn't say it in a very explicit, understandable way. What I was saying, that the arbitration agreement, what it says, that regarding the disputes arising from the contract or the performance of this contract, we will go to arbitration. Regarding the disputes related to the substantive claims, we give the jurisdiction to the tribunal. So the court loses the jurisdiction. Okay? The court cannot touch the substantive claims because the party don't want the court to intervene. The parties usually, this is the majority of the case, 99 something, do not say that in case we have a disagreement of whether an arbitration agreement exists, we will ask the tribunal, a tribunal, to see whether there is an agreement. So usually it's not the case. Okay? So because the party has not given the jurisdiction to the tribunal through an arbitration agreement, the tribunal is not entitled to deal with this case, because its jurisdiction is given, it's not inherent, like the national courts. So in principle, the forum that's entitled to decide any conflict, legally relevant conflict, is national courts. So that's why I argue that in the usual cases where parties only give jurisdiction to the tribunal regarding the substantive claims, then the issue regarding whether an arbitration agreement exists or if is valid has to fall back to the natural forum. Okay? But our arbitration law says no. This case, as I have explained, is Article 46(1). Is the tribunal the first one to decide whether it has the jurisdiction. So there are two layers of conflicts. One layer is the substantive claims, but to see who is entitled to deal with these substantive claims, we have to solve another problem, which is previous to this problem, is whether there is an arbitration agreement. So for these, the parties have not given the jurisdiction to a certain tribunal. The parties allegedly gave jurisdiction to the tribunal to deal with the substantive claims, which is in the lower level or a second level. So for this first level, no one gives jurisdiction to a certain tribunal, then falls back to the national court. This is my argument. But this is not the case, because the arbitration law provides that in this scenario, the tribunal goes ahead with this problem. And then afterwards, the courts comes in. So jurisdiction regarding the substantive claims for the tribunal is given by the parties. Jurisdiction regarding the arbitration agreement is given by the law. I don't know whether it's clear enough. So we can still argue this later on. So if this is the case where there is a substantive claims but the parties do not agree on what? On the existence and validity of the arbitration agreement. We have to go through this. Then Article 14 and 46 pop in. We have to follow the provisions in Article 14 and 46. But when the parties solely discuss whether there is an arbitration agreement, for the sake of knowledge, I would argue, because it's useless. Why do I know that there is an arbitration agreement, not for knowing who is going to deal with my dispute with the other party? That's why I say for the sake of knowledge, that lawsuit dealt with the previous case that I mentioned, then I would say, see this thing this way. There's no substantive claims, right? The claimant did not ask the court to check whether the claimant has certain right or the defendant has breached certain contract. No substantive claims. Then the dispute regarding the arbitration agreement is not instrumental, because this is exactly the subject matter and the sole subject matter of this action for mere assessment or appraisal. The sole object. After deciding this subject, nothing is left. Okay? So, there's no need to find out whether there's an arbitration agreement for this purpose, to see who has jurisdiction over the substantive claims, because there are no substantive claims. So no substantive claims, I don't have to check who is going to deal with these substantive claims. Then there's no need to find out who decides. Is the court or the tribunal the one who decides whether there is an arbitration agreement? So in this scenario, I would argue that the court and the tribunal are in competition. Both of them are competing to have the jurisdiction to rule on the conflict regarding the arbitration agreement. And the law says so. First, tribunal, and second, court. They are in competition. In a certain way, regarding the substantive claim, is also the court and the tribunal are competing one against each other. But the solution lies on the arbitration agreement. If there is an arbitration agreement, then the court loses. If there's no arbitration agreement, the tribunal loses. Okay, so on this level, we have competition between the tribunal and the court. In this level, there's no competition whatsoever. We can read the Article 14.1, which states that a court before which an action related to a matter covered by an arbitration agreement is filed, then it shall do something. So you can see the law is clear. When the action is related to a subject matter covered by an arbitration agreement, what subject matter? Is the substantive claims. It's not the arbitration agreement itself. Okay? So the subject matter, the dispute on the merits, is covered by an arbitration agreement. That Article 14.1 says, courts hands off, tribunal comes in. This is the setting of these two provisions. And the New York Convention says, in this scenario where there is an arbitration agreement covering the subject matter brought before the court, the New York Convention says the court should refer the parties to arbitration for the matter covered by an arbitration agreement. Again, this is the subject matter covered by the arbitration agreement. It's not the arbitration agreement itself. So And by the way, if it is not this, the correct approach, I would argue. Imagine that in this lawsuit brought by the claimant asking the court to state that whether there is an arbitration agreement, according to Article 14, which is the provision that the court applied, the court should refrain from dealing with the merits and dismiss the case, and if it invokes New York Convention Article 2.3, then it should refer the parties to arbitration. Imagine the parties follow this order from the court. Go to arbitration, and arbitration also follow the court order. It says that it should be the tribunal to deal with the existence or not of the arbitration agreement. And then the tribunal says, okay, there is arbitration agreement. I'm competent. I have jurisdiction. Over what? In this case, where there is no substantive claims filed. Do you understand? I'm focused on the lawsuit that in this case. Because we have to look at the case and see what the claimant asked for. So if the parties go to arbitration, the tribunal will say, okay, there is an arbitration agreement according to which I have jurisdiction. But it cannot go any further because it's nothing left. Party has not, the claimant has not filed a substantive claims covered by the arbitration agreement. So this is my approach, and this is why I say that there is no competition and only the court has jurisdiction in this case. So I'm running really late. I'm not going to this slide, but basically I have gone through it. And now, what next? So the tribunal, the court has jurisdiction. It should entertain this case. But the claimant is doing something repugnant. That the arbitration proceedings ongoing in Hong Kong. Why do you want a piece of ruling saying that there is no arbitration agreement when Hong Kong has said that there is an arbitration agreement? And for me, this is the scenario where Article 7.2 and 7.3.1 pops in, is that the rationale of this provision 72 is that you only ask the court to intervene when it is needed. When you don't have a procedural need, you don't ask the court to intervene. We have more to do with other stuff. You don't come to bother us without any need. And Article 73.1 says, if this is a mere appraisal assessment case, then only when the party is in a state of objective and great uncertainty. And this objective and great uncertainty has to be, I don't remember, I think it's manifesto, clear, objective, and grave uncertainty. So when you really need this declaration, then you come to the court to ask for this declaration. Otherwise, you don't come. It's not because you want the piece of paper to hang on the wall. No, sorry, I don't entertain these kind of cases. So this is the situation regarding this lawsuit. So I would say that, is there any means for this claimant to address his anxiety? Yes, there is. We have gone through this, which is Article 46.1 that entrusts the tribunal to decide first whether there is an arbitration agreement. So clearly, there is a legal means through which the claimant can have its anxiety problem solved. So if you don't agree, if you say that there is no arbitration agreement, you go to the tribunal to ask for an assessment, not here in the court, because you don't have any problem if you have the means, you are not in a situation where you are not protected. And then you have Article 46(9) that says that if the tribunal still says that there is an arbitration agreement against what you think is correct, then you go to court and ask the court to decide. This is when the question is ruled as a preliminary question. So the tribunal can rule through an interim award dealing with a lot of issues, namely whether there is an arbitration agreement. So in these two scenarios, you can go either to the arbitration, to the tribunal, or to the court. You have all the means at your disposal. Why you come to me, right? So I would argue that the court, instead of using Article 14, should use this means to dismiss the case, because there's no procedural need for the claimant to ask for the court to do an appraisal. Okay? So this is where I reached until last week. Last week, at the end, there's a question asked. One of the participants asked me about whether in the phase of enforcement, is there any means to address this problem? And then by that, I said, yes, I have overlooked something. I don't remember that there's also a means to address this problem is when the decision is by the tribunal is given in the final award, the losing party, when the award is asked to be enforced, then the losing party can rely on Article 69(2) to object the enforcement, stating that there was no arbitration agreement. This is the help that the question helped me to understand more of it. And another help came 2 days later. Someone told me, you know, there was another case dealing with exactly the same scenario, but the court has took another approach and made me realize something, that if the arbitration procedure is held outside Macau, then the parties cannot rely on 46 nor 49, on 46 of our arbitration law. They cannot come to Macau to ask our court to assert whether the decision made by a tribunal outside Macau was well made or not. They can't, simply cannot, because we don't have jurisdiction to check this part under Article 46(9). Okay, so I said, okay, I overlooked something, so, which is this case that I brought in is related to an arbitration situated outside Macau. In this scenario, what should the party do? Because in the relevant jurisdiction, this case in Hong Kong, there might not be these two provisions. So I went to the Hong Kong arbitration law ordinance and check, which is also an ancestral model law jurisdiction. Basically, it incorporated all the provisions of the ancestral model law on arbitration, just like us. So they do have this provision, which are provided in Section 20, which refers to Model Law 16.3, which corresponds to our Article 14.1 and 2. So, which means the parties can rely on the fact that the tribunal will dismiss the case and ask the party to go to arbitration. And also, Section 34 of the arbitration ordinance refers to Model Law Article 16, which corresponds to our Article 46.9, which is entrusts the court to rule on the decision made by the tribunal after in the final award. So in Hong Kong, they do have these two measures to ensure that the losing party can address its problem. So this is the situation where the award or the arbitration proceeding is outside Macau. So what I want to say here is that when we look at this case, if it is a arbitration outside Macau, we also have to look at the means provided in the arbitration law in this jurisdiction to assert whether the relevant party has the means like us to address this problem. But anyway, if there's none of this, we can still have these two means, which is the when the enforcement stage or recognition stage, the parties can come to Macau and assert that although the tribunal over there has asserted that it has jurisdiction, in fact, it doesn't have, because there's no arbitration agreement in the stage of enforcement and recognition. So anyway, there is means for this purpose. So what I say is, insist that the court should have dismissed the case based on this and not on Article 14. This is totally a different scenario, because Article 14 deals with the cases where there are substantive claims filed, which is not the case. And with this, I come to this decision that I gladly read it, because it is so well done. I was really amazed, and thumbs up for this this case. So the scenario is exactly the court case is this one, and the scenario is exactly the same situation. I'm not going to repeat it. And the court starting by checking whether there is the procedural requirements for this action were met. So whether what are the requirements, is there an objective and grave uncertainty for the claimant to file this lawsuit here, to ask me to provide a declaration stating that there was no arbitration agreement. He went on analyzing this. So he went through, and this is where I find it so brilliant, the judgment of the court of first instance, that I cannot refrain myself from citing it. So first, he take about the Hong Kong situation. He says, Hong Kong, there's no problem at all, no uncertainty, because the tribunal there has ruled that there was an arbitration agreement. No uncertainty whatsoever. And here, the court of second instance upheld the decision granted by this CFI, and more than that, it added. The decision given by the tribunal there has not been subjected to the setting aside proceedings, which means the claimant did not ask the Hong Kong court to set aside this decision handed down by the tribunal. Under model law, Article 16 of the model law, referred by Section 34 of the Hong Kong Arbitration Ordinance. So the issue has become binding, is re judicata. The second instance, the court of second instance stated that. So in Hong Kong, the problem is done. And in the court of first instance, said something else. It says, and the claimant did not tell me what's the point of having a decision here in Hong Kong. What is the impact of my decision in Hong Kong? I can answer him, if I come across him, I'll answer none. Why? Because Section 34, which refers to Article 16 of the model law, says the decision is not subject to appeal in Hong Kong. It's exactly the same of ours. So if imagine, in Hong Kong, after the Hong Kong court ruled that there is no arbitration agreement, just uphold the decision of the tribunal, it does not allow upper courts to intervene. Would they allow Macau courts to say there is no arbitration agreement? Of course they won't, right? So that's why I say none, no impact at all. It's useless. It's a useless piece of paper. And the Court of First Instance went on to say, regarding Macau, only the two conditions are met, then my intervention is useful. First, if the tribunal in Hong Kong rule against the claimant, the arbitration is ongoing. How can you state that the outcome will be what? Of course, the claimant foresee that he is going to lose this case. That's why he is doing all these maneuver to avoid being bound by the award. But anyway, at that point of in time, there's no award. So how can we tell what is the outcome? So the tribunal says, before this is done, there's no need of our intervention. And only after that, we have to fulfill another condition, is that the winning party comes to Macau to ask for recognition and enforcement. If he doesn't come, why do we need this piece of paper? For what? Okay, so brilliantly argued, very well done, and the Court of First Instance say that there is no objective and great uncertainty because there are plenty of ways for there are means. This one for the claimant to address is anxiety. Okay, so this is what I want to refer to. These two cases which made me very puzzled. The first one especially, and the second one helped me to clear ideas. And finally, regarding arbitral award, the court can come to help to supervise the award. So here, the one thing that I would highlight is there's no appeal in the Macau system to try to appeal against an award. Only when the parties have agreed beforehand that there is an instance of appeal. But this instance of appeal is not the court, it's another tribunal. So very tightly limited the chance of questioning the award on the merits, not on the procedural problems. On the procedural problems, the means to target an award is to get it annulled is through challenge. I'm not going through all this detail because it's not that important. So I have prepared this this slide to sum up all this. To highlight this idea, the pro-arbitration stance of our legislator. So very pro-arbitration provides all the, not all, most of the means to ensure that arbitration can proceed without interruption, avoid this kind of delaying tactics, to let it go while some other issues is still pending. So very wise structure and very helpful for the for arbitration, for Macau to become a chosen seat for arbitration. So with this, I end my presentation, and thank you very much for your attention. I took too much time for this explanation. Okay, I don't know whether there's any observation, comment, objection, question. So it means that, total failure because you don't understand the rubbish that I brought here, or you fully understood what I said and agree with without any objection.
Very quickly. So I'm understanding that ad contrario, you are arguing, however, if there was no case running in Hong Kong and someone would directly come to Macau where there is not an ongoing arbitration case, you would argue that it would be that the Macau court would have competence to determine whether the clause exists or doesn't exist.
If this is a solely question raised by the claimant in the case, the fact that there is an arbitration proceedings going on or not the solution is exactly the same, because we are not dealing with Article 14 and 46 problem. Article 14 and 46, the problem is when you have a substantive claims, but by chance there is an arbitration agreement that which states that this problem, this conflict should be dealt with by the tribunal, then you follow the procedure of 14 and 46. Where it is solely the problem of whether an arbitration agreement exists or is valid, then it's solely a problem of Article 72 and 73. So the fact that there was an arbitration agreement, proceedings going on in Hong Kong does not affect the outcome.
Thank you.
As far as I understand, there is this problem even in Hong Kong. I've read something because of other problems. I've read that even in Hong Kong, there are some these situations where parties try to avoid arbitration in this through this means.
You request. There's a variation of this problem where instead of requesting the court in Macau to do a declaration that arbitration agreement doesn't exist, you ask for a common interim measure to order someone to either stop an arbitral proceeding or order someone to not start arbitral proceedings, which is an interesting variation of the same problem.
Yeah. So the objective is the same, to obstruct arbitration, but through another means, because they don't have this kind of lawsuit where you can ask the court to do an appraisal or an assessment regarding a situation. Yeah, it's good to know that people, it's not new, it's not something created here in Macau, but something that losing party tend to use all means at their disposal to avert the final award or be bound by it. Yeah. So very good, and thank you for coming, and hopefully in the future we will meet again. Thank you. And if anybody is interested in the PPT, just let me know. I can provide. Okay, I'll send it to you.